Well, good morning, everybody. Happy Cinco de Mayo. It is obviously May 5th, 2022, and I'm really excited today to talk about preparing witnesses for depositions and for trial testimony. Preparing a witness is a tricky road. It's a tough thing to do, one, because preparing anybody for anything is a difficult thing to do. Second, there are certain rules, ethics, and guidelines that we need to navigate and make sure we don't go over the line. I'll tell you a story about somebody who went over the line, one of my most recent depositions, and I think you'll enjoy that. And then you want to make sure that you are allowing the witness to be him or herself. You want the witness to be who they are, while also incorporating the practice and the preparation that you help them with. So this is a topic that that I've been scared to talk about. I'll be frank with y'all. Someone suggested this topic after our last webinar, and I remember when I read the note that I got, my thought was, shit, this is probably a pretty good topic. It's been one that's been on my mind, but it's been one that I've shied away from because it is, I think, really difficult. And frankly, I don't know if I do it the best way, whatever that means, best way. If you've listened to any of these webinars before, you know that I'm hesitant to talk about anything being the best, certainly any of my ways being the best, because I think different ways work for different people. So as always, my goal during this webinar is to provide you one, hopefully two, maybe I'll blow it out of the water because I have a great guest and we'll come up with 3 things that you can do to improve the way that you prepare witnesses. So I'm trying to give you at least one, hopefully 2, long shot 3 ways to make your job and your cases and your witnesses and your clients better. So without further ado, I'm going to not do all of the heavy lifting today. I'm going to bring in Maggy Randels. I've known Maggie, I think she can tell me if I'm wrong, since she was in law school. But Maggie is a lawyer with Shiver Hamilton Campbell. Now, shout out to Scott Campbell, who's a partner and been a partner for a little bit. But she's a lawyer over there. She does some amazing work. She's somebody that when I have questions, I pick up the phone and I call her. And usually she makes me feel good while also telling me the obvious and simple answer of the question that I'm trying to get. And she also, and I think this is important to say, to tell you what kind of person she is. She's one of the most giving people in terms of her time, whether it's through, I can't even tell you all the volunteer organizations and giving back to students, whether it's on the high school level, the college level, the law school level. So I'm excited to have her on here, and I will say in her stay that if you need something, she will always be available. Look at this. She's answering a question right now in her office. Maggie, hop off mute. And if you'll just introduce yourself to everybody, literally as you help someone right before this.
Hi, everybody. I'm Maggy Randels. I am, as Mike said, an attorney at Shiver Hamilton Campbell, coming up on my 5th year at the end of this month, doing plaintiff personal injury work, which is crazy. I think Mike is right. I think we met, he probably benched me on a team when I was in law school. So yeah. And he's right. I coach a lot of mock trial. I spend way too much time doing it, but I think it makes me a better lawyer to learn, different perspectives from kids and students all over the place. And I'm excited to talk about prepping witnesses today. I think it's one of the things you can do as a young lawyer that can really set you apart is witness work, whether it's with a client or with just the eyewitness coming in off the street. So I hope we can help y'all. And
I'll give you the other end of that. I think you're 100% right. It's as a younger lawyer working for, a partner or somebody else at your firm. It's a thing you usually get asked to do. At least I did the most. And on the other end of the spectrum, though, if you're the only one doing it, or if it's something that you pawn off to someone else, for the most part, I think it's also a thing that can get left in I don't know the phrase here, left in the dust, left in the clouds, that it's something that you can forget how important it is if you're not doing it every single day. So I think on both ends of the spectrum, it's extremely important. But also, Maggie worked at one of the best defense firms before becoming a plaintiff's lawyer and worked on some of the biggest cases. Is it fair to say in the world, in the country at least?
Definitely in the country. I guess
Yeah.
now the client that I defended also has worldwide presence with some of their mergers. So I think they may now be some of the biggest cases in the world as well. And I clerked for a federal judge here in Atlanta before that, which was also a fantastic experience.
Well, don't smoke cigarettes, kids. Don't smoke cigarettes.
Also, don't vape.
Yeah, I guess that might be worse. That might be worse. All right. So, Maggie, I told you that our goal, I've given you our goal together. I've made it for you. Our goal is by the end of this that we can give us as close as we can get to some sort of step-by-step approach to people of generally, here's what you're going to want to do first. Here's what you want to do second. Here's what you're going to want to do, so on. So let's start with the first thing. What is the first thing you do? And let's make this easy for the time being, because I think we do have a fork in the road coming up in this conversation where on one hand, we have preparing your own clients. And on the other hand, to the extent you can, you have preparing a witness who is not your client, but at least is willing to talk to you and get a little help before they testify. So let's just stick with our client because you have a little bit more control over that person. What's the first thing you do when you realize I need to start preparing this person for their deposition, let's say?
I think the first thing you have to do is prepare yourself. And that's certainly the first thing I do, because if you don't know what's in the records, if you don't know what's out there, then how in the world are you going to prepare your client for what type of things they're going to be asked? And even kind of step zero is make sure you have everything from the defense. So as soon as we put this in our interrogatories and RPDs, but as soon as we're starting to talk about scheduling a deposition, it is always on my list to send an email to defense counsel and say, have you produced everything you have from non-parties?
I got to show you something. Will you tell everyone the amount of preparation we did or did not do? How many minutes was there? Like, give everybody
7 minutes of chatting.
All right, do you have any
idea about tennis?
All right, here we go. So I just want to show this. This is what's on my notes so far. There's no way I'm not that quick to type, but make sure you have everything for defense counsel is maybe the most overlooked thing that you can have, or that you do, because you show up to the deposition, then you start seeing these new documents and you're like, what is this? And I always want to lock defense lawyers in. They say, make them make a choice. If they say, no, I'm not giving everything because for some impeachment, I want to know that before going in. So anyway, I think I echo this statement that you want to ask, do I have everything? Are you withholding everything? Do I have a privilege log?
Yeah. I mean, that starts from the beginning, from your 6.4 letter, when they probably object to your RPD that says, give me everything you have from non-parties. And they send you some BS objection this is overbroad. No, it's not. Give me all the documents and then follow up again. And we've done it before, where we've said, give us all the documents and give them to us by a week in advance, or we're not doing this deposition. I have canceled and rescheduled a deposition because we didn't get the documents with enough time to review them.
Yeah, if you don't answer my question of if you've produced everything, my client's not going to sit for the deposition. Just not going to do it.
Yeah. So, and I'll tell a story, not one of my witnesses, but what really woke us up to this, probably a year or so into when I was practicing, another attorney, I don't remember if it was at a deposition or at a mediation, but some document showed up about prior symptoms in the same area. And lo and behold, that changed the case. And of course, the witness hadn't been prepped before her depo. The client hadn't been prepped. So she forgot about it, which happens all the time.
Yeah. Yeah. I had a case where my client hits a tractor trailer as he's driving down the road. Tractor trailer, we think it blew a tire and we think slowed down significantly. It was on I-20. And our client rear ends the tractor trailer because one, the tractor trailer swerved over in his lane. Two, he slows down out of the blue. So we're going through this deposition, and I had been promised we have everything. And here comes these questions about sleep. I'm like, that's weird. Why are they asking my guy about sleeping? And come to find out, he had been going to a sleep therapist. Well, shouldn't say he had been going. He once went to a sleep therapist, said he was having problems sleeping, said he fell asleep, and was worried about it. This was like years before this. Never had any more problems. Well, I think in all truth that the lawyers, staff, or whoever sent out the actual subpoenas to all these providers, they just forgot to give them to me. I'm going to take that approach, that they just forgot to give them to me. And I think it was just an oversight. But there were subpoenas and records that I never knew about. And that happens at the middle of deposition. As you know, and as everyone on here who knows me can imagine, I stayed calm, cool, and collected. I didn't raise my voice in any way. And I didn't get upset at all. I took a very calm approach, and we talked it out eventually. But that's, I looked back though, and I had that email that I said, do I have everything produced? And the answer was yes. And that wasn't right. The deal we made actually out of that deposition was, instead of me moving for sanctions, that you sent subpoenas and didn't give me notice of them, and then use those documents that I didn't even know you had. They let my client, what we did was we let my client review the documents and did a second deposition, and agreed that they would not use a portion of the transcript that was the blind side portion of the transcript. So that's what we came up with in that situation. All right. So once you feel confident that you know the case, that you have everything so that you can know the case, what do you do then?
Well, I've done it a couple different ways as far as starting to prepare clients. And I guess let me step back. So once I feel confident, I know everything, I also make a list of notes for myself, because even if I know it in my head, I want to have that document. I call it like client depo prep, and put it in my notes folder that I, then go back to when I'm actually in the meeting prepping the client. But I usually, once I know everything, I schedule depo prep with the client in person if possible. I've done it via Zoom. I think it's better in person. And I usually do it the day or 2 days before. I find that day of is not enough.
I'm not criticizing. I'm thinking of that. That's risky. That's scary to me, a day or two, because I've had clients who they needed days, or they needed more time than that. I guess though by who your client is for the most part, right?
Yes, I have clients who I know it's going to take longer for them, and I know they have voluminous past records, and then I will do it. I may do multiple sessions. I may start on the phone and then bring them in a week before, and then also bring them in the day or 2 days before. And it just depends. I also have clients who I know if I prep them the week before and then just the day of, that's not going to be enough. I mean, or they'll forget what I told them a week ago. So I think there's no hard and fast rule on that. It depends on your client. But set a meeting to prep them.
We try to do it. Our general rule is we do about a week before, and then I want to talk to them in some way for a significant amount of time the day before, 2 days before, to kind of remind the important things and also practice with them. Practice is probably, I'm writing my notes as we go. Practice is kind of the most important thing that I want to see before the actual deposition. Do you guys use a piece of paper, a sheet, notes, or something that you give to clients with any sort of rules, tips, strategies, anything like that?
I have done that before, where I've, sent a depo prep letter before.
It's such a defense lawyer thing to do. Doesn't it feel like such a defense lawyer thing? Like, I build my file.
I have not been doing that as much recently. I don't think people really read them that much. I do give them their interrogatories to read and make sure everything is accurate, and often send them home with those to look at. I start with 3 general rules that I give them.
All right, hit me. What are they?
All right. So rule number 1 is tell the truth.
That's a good rule. Good rule.
Yep.
Okay.
And
rule 2.
It's a kind of tell the truth, but tell the truth in the most advantageous way. So I kind of start prep with that. Rule number one is tell the truth, but I'm going to tell you some things today of how to best portray the truth. But if I ever say anything that's inaccurate from your perspective, then tell me, and don't say it that way. So that's rule number one. Tell the truth in the most advantageous way.
All right. What's two?
Rule number two is just answer the question.
Your rules are way nicer than mine. My rules are don't lie, answer the question, then shut up. Like my rules are mirror yours, but you have a much more tactful way to say this.
And my explanation I give for just answer the question is, in normal conversation, I go more into it than this, but in normal conversation, if someone asks you, do you have the time? You'll look at your watch and say it's 9:49. But in a deposition, the answer is yes.
Yeah. How's your day? Fine.
Yep. Do you have any relatives in Gwinnett County? Yes.
Yeah. I mean, the way I look at it is, especially for defense lawyers or really anybody that's using a script or using even just a topic outline, God forbid they use the script. I don't know, a month ago, one of my clients got asked, do you typically ride ATVs? And I'm looking around, I'm like, am I missing something? So I later asked my client, I was like, what, do you know what he was asking about with the ATVs? And it was just on a script. And I said to the defense lawyer, what were you doing asking about ATVs? What did I miss? And he goes, oh no, it's been on there. So, I have to ask it. And I was like, oh geez. But anyway, the way I look at depositions is you're going down a road, and your job as a witness is to get from your house to the destination as quickly as possible with as few bathroom breaks as you can take. If you've got kids, I don't know, make them go to the bathroom before they get in the car. If you have, an annoying significant other, make sure they get all the snacks and charge their devices and whatever. So that way you don't have to stop off the road. And every time you give a little bit more information, you're letting them take a detour on the road. So, when you say, hey, have you ever been involved in a crash? No. Or I guess the question would be, have you ever been involved in a motor vehicle crash? No. Okay, you've gone another mile down the road. But if you say, no, but there was this time I was on a boat and I got in a crash on a boat. Well, shit, you're going down a long detour right there. And there's no reason to do that. You answered the question honestly with a no. It's make the lawyer work. It's the lawyer's job to discover information, not for you to help them learn about you or your case or whatever it is.
Yeah. One of the biggest compliments I think I've ever gotten during a deposition is I prepped the client, and I don't even remember what the question was, but she does exactly that. It was some question that, in normal conversation, you'd give a big list. I think it might've been, do you have people who know what happened to you or can talk about your injuries? And she answered yes. And the defense lawyer just looks at her and goes, dang, you're making me do my job. Yeah. So I now tell that story to clients and say, I know that you will get this if that's the response you get from the defense lawyer.
Yeah, it's tough to do that with really nice, friendly, happy clients, because you've got I call him the guy who waves in the neighborhood. So if you've got the neighborhood waver as a client who I think of my grandpa, he drives out of his neighborhood, he rolls down his window, he talks to everybody, including dogs and trees, and says, hello. If you've got that client saying to somebody, hey, when they ask you a question and the answer is no, don't explain it, just say no. It's really tough for those clients to do that. I mean, I've have a gavel and I've hit it in preparation and like prep, nope, you're going too far. Nope, you're going too far. And that's, that's not something I regularly do. I've done it once, but that's that's probably the hardest thing to explain to somebody, that testimony in any legal setting is different than a conversation. No matter how many times the lawyer on the other side says, we're just having a conversation, I'm trying to get to know you so I can figure this out. No, this is these are statements under oath, and that's a different thing. I'll add a rule. Just answer the questions, and I'll add to your rule. Just answer the question as long as you know the answer. If you don't know the answer, don't answer it. And I spend a lot of time explaining to clients that, like right now, my parents just moved to North Carolina. If you ask me where they are, my answer is they're in North Carolina. Do I know that though? Like in a legal sense, am I willing to say that under oath? Where are your parents? If it's you and me talking, I'm like, yeah, they just moved to North Carolina. They're there. If I'm asked that question under oath, my answer is going to be, I don't know. Now, if you ask me where I think they are, I'll answer that question and tell you North Carolina, but I don't know. And that's really tough to explain to clients that you don't know sometimes what you think you know. That is such a limited area of what you know. Now, on the flip side, you want to make sure clients aren't saying, I don't know for things that they clearly should know. That happens a lot. I told you, I had a witness just the other day that anytime the defense lawyer talked, anytime the defense lawyer said anything during the deposition, the witness says, in response to my next question or the question that was pending, says, I don't know. I'd have to speculate to answer that. I don't know. I'd have to speculate to answer that. And it was ridiculous. But I think it's really important to make sure that clients know what they know and realize that they don't know what they don't know.
And you brought me to my third rule, which is don't guess.
Yeah.
And I, especially in car wreck cases, I specify, especially with respect to time, speed, and distance.
So one of the lawyers at your firm worked for somebody that I worked for as well. And I can imagine, I think I know where that rule in your office came from, because that was beaten into my head now at this point, 8 years ago, something like that. Time, speed, and distance, time, speed, and distance. You never know time, speed, and distance. Now, I can think of a situation you may, but 99% of people don't know how fast they were going. They don't know how fast the other car was going, how many seconds in between things. And they don't know how far apart anybody was at all. And if you need to prove that to a client, ask them how far 10 yards is. And I guarantee they don't know it.
And I like to tell them the horror story of, if you guess and you say I was going 30 miles an hour for X number of seconds, you better believe the defense lawyer is going to get some sort of crackpot expert who is going to then come up with, well, goodness, it must have been their fault because here's the math.
We got a comment here that, what are our thoughts as to encouraging witnesses to say something like, to qualify their answers, to the best of my memory or as best as I recall? What do you think about those phrases? I don't know if I've ever really given this thought, so I'm interested to hear yours. I'll pass the buck for a second.
I do that, especially with respect to prior, we do a lot of spine cases, especially with respect to spine. I'll have them say something along the lines of, look, it's broad question. And I guess this is maybe a fourth rule, but, never, ever, always are always tough words. And so, first of all, I'll object to those questions and ask something like, in their whole life. But I encourage clients to say something like, look, have I ever had neck pain? Sure.
Who hasn't?
Can I remember the exact, have I woken up with a stiff neck? Of course. But can I tell you every time? No.
Yeah. Or was there any time like this that I remember? No, assuming that's the answer.
Yeah. And so I think those qualifiers can be helpful. It also stops the defense from getting a good soundbite of, have you ever had neck pain? No. And then heaven forbid, 15 years ago, they went to a chiropractor and said, I have a stiff neck. And we didn't know about it. And we didn't have the record from defense because they didn't have it yet. So I think it can be helpful.
I think my take on it is, and I'm looking at the phrases that Michael put in the comments. He'd use to the best of my memory and as best as I can recall. To me, they sound lawyerish, which makes sense. We've got, lawyers sitting here talking. In fact, my pet peeve is I hate the phrase, I don't recall. Like, who says that in normal life? You're like, hey, I can't find I can't recall where I put my keys. I mean, nobody's running around the house being like, I can't recall. You're like, where the fuck are my keys? I mean, that's what you're saying. So I want clients to be themselves. So what I try when they and this kind of ties in, when they don't know a question, I tell them to say how they would say it in normal life. I don't know. I'm not sure. I don't love those two phrases, but I do like the concept of making sure that you don't give, a always never answer, always never type of answer, because there could be something out there. I mean, who knows? In sixth grade, you might have went to the nurse because your neck hurt and you were just trying to get out of the test that you didn't study for and trying to get mom to bring you home or something. And who knows? There's defense lawyers that would be crazy enough to find those records. So, all right. So what I've got right now is you need to prepare yourself by making, and part of that, you need to make sure you have everything from the defense or the other side. We've got a couple of defense lawyers on here, I saw. And then when you prep clients, you want to tell them, tell the truth, but yeah, hey, help yourself, do it in the best way possible. Just answer the question. My version of that, just answer and then shut up. And then rule 3, don't guess, especially about time, speed, or distance. If we're other things that I think we've covered so far is watch out for always and never, always and never. You don't know what you don't know, and make sure you understand the difference between, or that your client or whoever understands the difference between what they do know and what they don't know on a legal sense. I think those are different. Anything else that comes to your mind?
Well, this is kind of a corollary of, just answer the question and then shut up. But I like to tell clients not to be afraid of silence, because that is one of the hardest things to do. And it is not comfortable to sit there and wait for another question, especially if you've done a good job and just given that yes answer, because, you're sitting there close to the lawyer and they're looking at you and waiting for you to talk. And a lot of people will want to talk, like your guy who waves at trees. He's going to want to talk. I mean, pretty simple on that front. And then,
yeah, well, I just made you talk. That's what I was just doing. I literally just made you talk by pausing.
You did. I broke my own rule.
No, but I mean, that is the truth, right? I mean, if you, it's the nod, at least that's what I do. It's the, what else you got? And I think that is actually a really good strategy. It's something you got to tell your clients to be careful of, but I think it's a really good strategy for lawyers. The silence just lets people think, and then they think of more things. One thing I've learned, and I try to remember this as much as I can, when I'm just like looking through my notes and there's a what most people would consider an awkward break where I'm not speaking, I used to always say, just give me a minute, I want to look at my notes, because that's the polite thing to do, I think. I find if you don't say that and you just look at your notes, somebody's going to say something, and that really helps. And if you're doing depositions on Zoom, one thing I really like to do is you can tell the court reporter to spotlight the witness. And what that does is, on your screen, you can do whatever you want. You can see everybody. But on the witness's screen, it makes the witness only see themselves. So the witness is just looking at his or her face. They don't see you. Maybe they see you in a little box, depending on the software, but I think they only see themselves. So they don't know what you're doing. They don't know if you've got a piece of paper, if you're whatever you're doing. And that's even better on Zoom for the silence technique, if we're calling it that, because they don't know if you're preparing to ask another question or you're waiting on something, and they'll just keep talking. Along that lines, you said you've done Zoom prep. What I've started doing is, if the deposition is going to be on Zoom, I prep on Zoom. And if the deposition is in person, I prep in person, with the caveat being, and I know we're only really talking about clients right now, but with the caveat being, even if it's in person and it's video recorded, so it's going to be played to the jury on a video, I will want to still prep that witness on Zoom. And the reason is, I want to see what the jury's going to see. I'm looking at you, I'm pointing at you on my screen. But if this was recorded, and it is, and this is going to be played, somebody's going to watch this on YouTube or something, they're going to see you on the screen as opposed to me and you sitting in the same room. So I kind of want to show that. But tell me some Zoom prep ideas that anything that's been different or you found works.
Well, as far as Zoom prep, and I mean, to be honest, I hadn't thought about it that much as far as prep via Zoom for Zoom, prep in person for in person. Often it's more, what will work for the client, so I can get them to show up and get prepped Um,
Yeah.
but I like that. And I think I'm going to start using that as far as prepping. But I like Zoom because you can sit there and show a document and highlight something even more easily than you can in person and point it out. But I also think in person is important because sitting in the same room with someone is just different.
Yeah.
And it's also easier to, I find it's easier to get things across in person sometimes. You know, if you need to sit there and tell them, shut up, harder to do via Zoom because you have to cut them off and they may not be listening.
Yeah.
I had a very chatty client who I prepped via Zoom for her in-person depot because she lives north of town and we were doing the depot here. And I wish I had prepped her in person because she, as much as I prepped her and as much as I practiced with her, she could not help herself in the depot from adding things. And
so what would you have done differently there if that's your only case in the entire world, right? I mean, because that's how I try to think about things. I know that's not always feasible, but if this is your only case in the entire world, what would you have done? What would you do differently if you're going to do this deposition again?
In retrospect, you know, if she couldn't get here, I might have just gone to her to prep her. I think it would probably have been worth the time in her case. You know, ultimately it didn't sink the case, but it could have. And I think the prep is worth the time. Don't forget about it. As Mike said, don't leave it in the dust. And you know, if it needs to be multiple sessions, it needs to be multiple sessions. If it needs to be one session of Zoom so you can see on video and one session in person so you can have that, like, sit there and shake them until they know to shut up, then do it.
Yeah. Here I pulled up, and let me open this up. We, like you, we used to use a prep sheet a lot and send it to clients. But I want to see if I can share this, and I'll go through and we can run through some of these tips and see what you think about these and if you would change any of these. Let's see. I'm going to share my screen. Here's our secret work here. You can see this, Maggie? I assume if you can, everybody can.
I can.
All right. So big picture, I always want to tell clients that the goal is not to hurt your case. You can't win your case at your deposition. I've never seen anyone win a case. I've seen lawyers be like, wow, your client did very well. I've certainly seen, I like to think that I've been on the asking question end of this, where I've made witnesses lose their case. I mean, I've seen that. So I like to make sure clients don't feel the weight or the pressure. You know, hey, you don't have to win this. All you got to do, especially for personal injury clients, I think your clients have the easiest job there is. All they know is I got whatever happened to me, and they know about their life, and that's all they're supposed to talk about. I think it's tougher. Like a corporate rep deposition is 100 times tougher.
I use that exact for not necessarily the phrasing there, but the phrasing, you can't win your case at your deposition, but you can lose it. And I tell them that. I say, look, all you have to do is just answer the questions and get out of there as quickly as possible. And if you truly don't know, that I don't know answer is perfectly fine. Don't be afraid of it. And
no, the worst answer is the answer that's not true. I mean, or an answer that's true, but you hadn't shared with me before the deposition, because I can only protect people who tell me things that I can then protect or guard against or do something with. Number two is the rule we discussed already. Listen, and this is especially for clients who speak too quickly. What I try to practice or have them practice doing is listen to the question, pause, make sure they actually understand what's being asked and only what's being asked, and then answer it and stop talking. I think that making sure you actually understand the question is really, really important. Only tell what you know. Be accurate about what you do or don't remember. Here's the comment we got earlier about, you know, the best I can remember. So I call it wiggle room. You know, that's all I can remember right now. These are the phrases I came up with. Or that's all I can remember sitting here today. You know, I might be sitting later somewhere else at a witness stand and remember something else. I want to make sure. I find that when clients, a lot of clients start talking lawyer-ish in depositions, even when they're not lawyers. And I want the clients to use their own words and say the story how they know it, or whatever their answer is. They want to put it in their words and not parrot back the lawyer's words, because that's what they want. You mentioned soundbiting earlier. For people who don't know, and I'll close this because I think this is an important topic and I want everybody to see you while you answer this. If somebody's new to the phrase soundbiting, can you tell them what it is? And we can talk about why it is so important, either to get sound bites if you're taking the deposition, or try to prevent sound bites if you're defending it.
I think the best example in my mind of a soundbite is that I think the example I gave earlier of, it's a spine case and they ask, have you ever had back pain before? And the client gives a one-word simple answer, no. Now, those 3 lines of that deposition are going to be cut and pasted and screenshotted and plastered over potentially a PowerPoint, used in cross-examination at trial, sent to the insurance company to say, and put next to that chiropractic record that they found. And it's going to be a really, really tough time.
Yeah. On the lawyer side, if you are 10, and this is a tad off topic, but I'm going to say it anyway. If you are taking a deposition and a witness says an answer that's a little convoluted, there's a window washer right here that's staring at me as I talk into the screen. But if I had this, that's a webinar first, the window washer. But anyway, if you get an answer from someone and you want to soundbite it, the way to do that is take what the witness said, repackage it, repurpose it, and get that yes or no answer. So what you're saying is your company has never done any sort of training for drivers who don't have a CDO. That's correct. And that may be the result of getting a question and an answer, maybe 5 or 6 questions and answers put together. Do you do training? Sort of. Well, do you do training for CDL drivers? No. Have you ever done any training for CDL drivers? No. Do you train them how to drive? Sometimes. And you piece all that together and you want to make the soundbite as a lawyer so you can get that yes or no answer. And I get worried when I'm defending depositions. The only times I get worried is when my clients are not listening and following the rules. Or number 2, I get worried when lawyers start soundbiting my clients and doing a really good job of that, of taking 4 or 5 questions and condensing it into one. That's when you have a lawyer who is experienced and knows what the heck they're doing. That might be the best and easiest way to figure if you have a good lawyer on the other side during a deposition, is if they start soundbiting your client left and right. In terms of lawyer talk, I'm gonna give you a warning here, Maggie. So forgive me. I once did a webinar where I talked about bad faith. Austin Bersinger was on that webinar, and I stand by everything I said during that webinar. At one point in the webinar, I said something like, "You don't." And this word, I think this is pretty damn close to word for word. Austin and I both said, "We are not telling you, and you don't need to trick or set up insurance companies. They're going to make bad decisions by themselves, and they might even make some bad decisions just by human error and truly just making a mistake. But you got to give them the opportunity to." So I just said that again. That webinar got cited in a brief against me in a bad faith case, which was kind of funny because I then played the webinar for the judge. But that's happened to me a few times. So before I ask this question, I'm just going to throw it out there that, this is going to go on the internet and that shit never goes away. So, and I'll give you my answer before I ask you the question. The question is going to be, how do you, during a deposition, if at all, help your witness? And my answer is, if you've ever had a case before, most Northern District judges, Dax Lopez, when he was a judge, Ana Maria Martinez, who's taken over, a whole bunch of judges, I think some of the Fulton County judges, they have a standing order that governs deposition conduct. And basically it says, don't speak and don't do anything, just say objection. And if you're asked to explain the deposition or the objection, you can do that. I follow that when I'm defending a deposition, mainly because I think that my witnesses are hopefully more prepared than theirs. And I would rather benefit when I take a deposition by holding their feet to the fire and holding them to those rules so they can't do anything to help their witness. My answer to this is I generally, other than making objections, I sit there, I pretend to not be listening. I'm very, very much listening, but I just be cool, like the Godfather. I just sit back and, try to pretend like whatever the lawyer's saying doesn't bother me and my client's doing a great job. I throw in the objections I need to. Maybe once in a very, very blue moon, I will say something like, if it, I don't know, a question where it's just an unfair question, I'll mention how unfair that is and very briefly explain why. But I would rather my client lose a couple points possibly by me not butting in some way, because I think I'm going to gain so many points by when I take the depositions and that lawyer starts coaching their witness. I'm saying that's too far. They're coaching, and I'll tell a story in a second after you answer this question. But what are your thoughts on that?
I'm pretty similar. I mostly stick to object to form. I will occasionally throw in if you don't know, you could say you don't know. Just remind them.
I think I would strangle you at a deposition, not for real, but like I would. You're going to be in my story in a second.
And then I have done. If there's agree with an unfair question, or if I feel like sometimes I can't help myself if the defense lawyer is just like not making any sense.
Yeah.
And I will, ask them a question and say, like, want to make sure we're on the same page. I thought this rec was in 2019 and you're talking about 2017. What? Where are we?
Yeah. I think those are fair. I think those are fair things to make sure that, make sure that everybody understands what's going on. The story I was going to tell you was like 3 weeks ago, maybe a month ago. I am just demolishing this witness. It's probably been the best deposition, frankly, I'd taken in like a year or two. I mean, like just, and the reason why it was so good had nothing to do with me, maybe a little bit, but mainly it was a corporate rep of a trucking company. The witness was like a really nice person and honest and like a good, kind person who, when you asked questions, gave honest answers. It was like the best witness ever. Like they just answered the question and it was honest and truthful. And when they didn't know, or they didn't have a good reason, instead of trying to make one up, like, it should be an admitted liability truck crash and it's not. So I had some fun going through the answer and saying, why did you claim that my client who got rear-ended, assumed the risk of being rear-ended or somehow was negligent or, blah, blah, blah. And she would just say, I have no idea. That doesn't make any sense to me. And I'm watching the defense lawyer, his case just crumble. And I mean, and also see that his strategy of deny everything is backfiring. And he says to the witness, I actually put this on a LinkedIn. The day it happened, I put it on LinkedIn because I was just furious and venting on there. But I asked a question and it's an impossible question to answer, right? The answer is, I don't know why. That doesn't make sense to me either. Like that's the answer. And he got so sick of her giving that truthful, honest answer that he just says, well, at least say you don't know. Just say you don't know, or something like that is what he said. And I was like, oh, what? You're literally just telling her how to answer the question? Obviously, people don't do that. But there is an art, there is a skill to interjecting for obviously a legal reason, a reason that you need to object and preserve some sort of right. But I think there's also an art to making sure that that your clients have a fair chance to answer questions. And I'll say the one time I am willing to butt in is when I don't think my clients are getting treated fairly, or I think the questions are somehow unfair. And my rule with anything is, even if that standing order is in place, if it's an unfair question and my client's being treated unfairly, I'm going to butt in. And if they want to go to the judge, I'm going to say to the judge, this was unfair. My job is to make sure that everything is at least this is how I see my job. And I'm fine standing in front of a judge saying that I was making sure things were fair. What I don't want to do is I don't want to be on a transcript making things unfair and getting an advantage for my client by butting in. That's what I try not to do.
I completely agree with that. And I don't think I would ever say, just say you don't know.
Yeah, no, I know.
But no, one thing I always tell clients is, look, this is your day to sit here and make a good impression. So you don't get angry with the defense lawyer. If they are doing something unfair, let me get angry. Let me be upset with them because they already, they already know I'm a problem, and I've sent them 35 emails saying, where's all my stuff? And they probably already dislike me.
Well, and
they respect me.
I'll send out my sheet that I'll send out my sheet that I pulled up, but the next one on my list was let your lawyer, meaning me and you in this situation, take the heat. So if something's wrong, or if there's a way that you can blame your lawyer, blame me. I mean, let me be the fall guy if I need to. So, what evidence do you have to support this paragraph in your complaint? I don't know. You'd have to ask my lawyer. He's got everything. He's doing a great job. What evidence do you have, or why didn't you give me this? Well, I gave it to my lawyer. I don't know why they didn't give it to you. You'd have to ask them. And, hopefully you have a good reason why you didn't give it, but I tell clients, let the lawyer take the heat. And if you start getting frustrated at the defense lawyer, just ask for a break, because I know you're a tad sarcastic, can be sometimes. I certainly can be. That does not come across on transcripts well at all. I mean, at all. I have a transcript, and I'll see if I can pull it up to show everybody. I have a transcript that's the perfect example of this. But what do you do when clients are starting to get irritated or bothered or, upset? Maybe they've made a mistake. They've said something that they wish they would have said differently, and they're frustrated. What do you do at that point?
I often will take a break. I like to think I know my clients, and I've spent enough time with them to know if they are getting frustrated, like you mentioned, or if I think they're starting to ramble on too long sometimes. I mean, I'm not going to do it 10 minutes into the deposition, but at a good time, take a break and just let them calm down, get a drink of water, reassure them. I always keep in mind in the middle of a deposition that, arguably those conversations are not privileged and could come on the record. I don't usually push that with defense lawyers, and I haven't been pushed on it, but I still keep in mind and, keep the things to tell the truth, answer the question. I don't care if that comes out on the record that I told the client in the middle of the deposition in a break to tell the truth. Please ask that I said that. I'll tell a story one time, and this I think is kind of a tangent, but is important. I know a lot of us have clients who are not English speakers and will have to have depositions through interpreter.
Yeah.
And earlier on in my career, I think I didn't quite appreciate the dynamic of that and how important it is to prep. Not just the defense lawyer is not your friend and you're not having a conversation with the defense lawyer, but also the interpreter is not your friend, and they are hired by the defense lawyer and or by the other side's lawyer, and they should be there to you just answer the question. Don't have a side conversation with them. I actually had that happen once with a client who got male client who got very chatty with a female interpreter. His wife also had a pending case, and so after a break, we actually brought her to sit in the deposition, as she was entitled to do, since they both had cases pending, which I think calmed him down and helped him remember, hey, I'm just answering the questions here.
Yeah, I'm gonna show this real quick. I pulled it up. So in terms of sarcasm and clients getting frustrated, here's a quick little transcript. So words on the page don't have tone. They don't have voice or inflection. Here's my question. Do we agree that there are communications between you and Fane Major that you have not produced to me, correct? Yes. When he said that, he's rolling his eyes saying yes, but that is an honest answer. And the reason you did that is because you couldn't give me all the communications, correct? This is me, by the way, soundbiting things he had been saying for 2 pages. And he gives an answer. And this is the part I want to show y'all. This is 100% sarcastic. It's true, but it's still sarcastic. I'm just a doctor. I'm not a lawyer. Okay. So if that implies I should have given you some, then I apologize. You're right. And later on in the deposition, he goes, you're right. You're right. And he's saying it like that. Well, yes, I am right. but on the transcript, this doesn't come across. And this is not what, I think he intended in that moment, although it's an honest answer. So I just wanted to show you all that when clients, be really careful about when you have a client who, uses sarcasm or what they think is humor. That stuff's not funny on a deposition. It's not going to be funny 2 years later if you're at a trial and they certainly make a joke that in any way can seem off color or can seem insensitive. You want to be really careful about that. I've got clients, especially my smart ones, who try to be smarter than the defense lawyer. They get into a contest of I know more than you do. It is true. The client knows more because it's the client's life that they're talking about. So I have the one instance I have done a break that I can think of. I did a break, I think 4 questions into a deposition once because I was worried my client was one, going to answer and then expand. And 2, I was worried that my client was going to be really frustrated just with the fact of being deposed. To him, this was a case that so obvious, I'm hurt, give me the money, and I don't blame him for that. But I think on the 4th question, he goes something like, "Oh, is this how this shit's going to go for the next 6 hours?" And I went, "Oh, break, please. Need a break immediately." Now I want to talk to y'all about breaks. My approach is you can't talk to your witness about the substance of the questions or the form of their answers. I've reversed them. The form of the questions or the substance of the answers on a break, because you can't do that at trial. That's my approach, my belief. But I certainly will talk to clients and tell them, I'm trying to hype them, being their hype man. Yeah, you're doing a great job. Or say, you keep doing this, we're gonna have a problem here. I mean, you're not following our rules. I want you to remember the rules, but most importantly, and this is what I say to every client when we get done with a break, most importantly, make sure you tell the truth. And then if there's ever a reason that conversation has to be discovered for whatever reason, a judge says that I went too far or something, or the lawyer starts asking and my privilege is somehow questioned, I want the client to, one, remember, tell the truth, but also I want that to be said out loud. Oh, my lawyer told me to tell the truth. That's the last thing they told me. What's something in terms of a deposition prep practice session that you're looking for? Do you do them yourself? How do you go about that?
I do it myself. I have had paralegals sit in with me to just with certain clients where it could be more helpful. And I don't necessarily do a deposition prep practice with a non-client witness, but with a client, I'll specifically ask questions that I anticipate, particularly with tough medical records. That's where I find clients can go off the rails. I've had a client, despite being prepped on this, try to say that his medical record was inaccurate. So I think it's important to literally ask that question. And to be fair, it came up at the deposition. So it's a physical therapy record that has a 0 out of 10 pain scale in one place. Of course, later in the record, it has the 8 out of 10 or whatever it was pain scale that he finds more accurate. But I think it's important to literally show him here you said 0 out of 10 pain. And prep him on how to answer that, because
just to make sure that none of this gets taken out of context. I mean, when you say prep them how to answer it, it's figure out what the truth is and how to answer that in a way that's honest and fair and accurate, and also the most advantageous way to your case.
Exactly.
Yeah, I mean, I don't want that to be taken out of context.
Thank you for fixing my own soundbite.
Oh, you're fine.
Right, and if the answer is, oh yes, I told them 0 out of 10 pain on this day, then that's the answer, and I tell them that's the answer you have to give. But if the answer is, I don't know why that's in the record, that's a fine answer. I don't know. If the answer is, I can't say, maybe, and then this is where you can get into explaining too much. And I think it depends on the scenario as to, what the truth is for that client. as to how to explain it. But, I think one thing I advise clients not to do is to say that this medical record is wrong or it's a typo.
Right.
That may be the truth. I hope not.
I don't know. You'd have to ask my doctor. I'm not sure. I didn't write those records. I've never seen those records. They probably haven't seen the records. And that's something I just responded to a question while you were answering. But somebody asked, can the defense get a copy of your depo prep instruction letter? And I said, no, it's attorney-client communication. But I also think it's a good approach if you're going to give the letter to the client to get it back, to say, hand me that back before your deposition. I think it's important, for example, to show clients things, but you don't need to give it to them. So show them a video, don't give them a copy, show them their interrogatory responses, but those are probably the safest thing to let them keep. But show them the police report, but get it back from them, take it back. There's no reason for them to have those documents as a preparation in their hands, at least in a preparation session or at the deposition, just because you're prepping them with it.
Definitely don't leave anything. I think anything sitting in front of the deponent at a deposition is fair game to take a look at it. And also off topic on prep. But if you're deposing somebody and they have something sitting in front of them, get a copy of it, look at it, mark it as an exhibit. Or same thing on Zoom, if they appear to be looking at their screen.
Hold it up. If you have a piece of paper, hold it up on Zoom. Do whatever you can do. I'm just reading comments here. All right, so let's see if I can meet our goal here, because I've made a promise to everybody trying to say how we do this. I'm going to see if I can boil this down, and you tell me where I've made mistakes. So I think the first thing is you need to get yourself ready by making sure you have everything and you know your file. Is that a fair thing to say?
Yeah, I would say step 0 is make sure you have everything. Step 1, make sure you know everything.
Okay, that's a good. I like the step 0. Writing this out so I can send it to everybody afterwards. All right, step 1, prepare yourself. All right, and then in terms of preparing your client, we want to make sure that you start early enough. If you've got a client who is an all-star, maybe you don't need 2 weeks. But if you've got a client who needs help, make sure you start early enough so you have time to do things a couple times if you need to. We want to tell clients that tell the truth, but we want to help them as best they can portray that in a persuasive way that's most advantageous to them. I mean, that's why we're here. That's why we're their lawyers. Second thing we want to tell them is I'm going to add to your rule number 2. Make sure you understand the question and then just answer the question and stop talking. Number 3. Oh, go ahead.
I'll add in quickly to that. I'll tell them, if you don't understand the question, don't be afraid to ask the lawyer to rephrase or ask it a different way.
Yeah, especially a client who's embarrassed to say, I don't know what a word is, or I don't understand what that means. I see that with clients who are smart, but maybe uneducated. And they don't want to say, I don't know what that means, because, they're smart people. And they just don't understand. So I see that too. When you answer the question, only say what you know. Only say what you know. Only say what you know, and say you don't know what you don't know. That's especially true with time, speed, and distance. Time, speed, and distance. Be careful to qualify. We'll talk about qualifying, I guess, qualifying answers. Watch out for your always and nevers, and also if you can, if your witness can, especially on questions that are asking for, that maybe are using the always and never. Have you ever had this? Has this always been true? Well, as best as I know, as best as I can remember, as I sit here today, that's what I'm pretty sure is correct. And then in terms of actually practicing, I like to bring somebody else in, even somebody who doesn't know the case, just so it's a different voice. And even like right now, one of the lawyers in my office could pull me into prep and just say, hey, can you give this person, we call it the 15 minutes, which is 5 minutes on the 3 topics. At almost every deposition, you're going to cover 3 topics: who you are and what your background is, what happened to you, why are you hurt, and then how are you hurt. I mean, those are the 3, if you have an outline, those are your 3 main headings. So, if you've got somebody else in your office, it doesn't have to be a lawyer. You mentioned a paralegal. It could be, it could be the UPS delivery guy. It really doesn't matter. I think that anybody there needs to be someone else, I think, who will come into that deposition prep session and say, all right, where'd you live? Where'd you go to school? When did you move to Georgia? You ask those BS questions up front, and then, just switch topics on the person. So tell me, where were you going when you're in the car? Where'd you been? What happened? And just lets another voice give that, hey, have you ever been hurt before? Tell me about your neck on a scale of 1 to 10, how bad it is. And you can ask those questions even if you don't know anything about the case, because shit, a lot of defense lawyers come into the room and ask those questions and don't know anything about the case. So it's perfectly easy to do that. So one of my rules, as best as you possibly can, is have someone else have a different voice, ask some questions to kind of test your client and make sure they're ready.
And one thing we didn't talk about is really that section on how to prep on how are you hurt, what happened. And we talked about the pitfalls, but I think it's important with clients to jog their memory and help them remember how they're hurt and how this has really impacted them. And not every defense lawyer asks about it, but I would rather have them be prepped and ready to give concrete examples and not just, I can't do this.
I think that's almost the prep to the prep, because when I was a defense lawyer, my main goal walking out of there was figure out what happened and then lock the client in. I say client now because I'm on the other side, but lock the plaintiff in to all the ways they were injured, how badly they were injured, and what they can or cannot do anymore. I say the prep to the prep because I think you have to ask your client for a list before prep starts. Tell me every way that you have been hurt. And I think this may go all the way back to intake. On intake, if clients are still in pain, we give them a pain form. Most clients disregard it and just use their own. But the point is, I want them to know that every day they should be writing down, I wasn't in pain today. Oh, my neck really hurt bad today. My lower back was killing me, so I had to take an extra pain pill, whatever it is. And also asking friends and family before the prep session. And I'm glad you brought this up, but asking friends and family before the prep session, hey, what have you seen? What can't Karen or Susan or whoever, Dave, what can't those people do anymore? And I want my client to have a list of all the things. And I want that client to give me the list. And I mean, I had once had a client tell me that they couldn't go skiing and couldn't go cliff jumping, cliff diving, whatever that is. And I was like, oh my God, wow. How often have you done that stuff? Well, I never have was the answer. And I was like, okay, we're not going to go in the deposition and talk about cliff diving and skydiving and skiing when you've never done that. I need you to make me a list of all the things that you've done in the last 4 years that you can't do anymore. And I want that list. That's the only thing that I want from a client that's sitting in front of me, because if the client is asked those questions and the lawyer does a really good job of locking the client in, so, hey, the only things you can't do right now, you have trouble sleeping, cooking, driving, and standing for a long period of time, right? And if the client agrees that, and I have this list of 47 things that the client can't do, I'm going to ask questions and clear that up afterwards. So I'm glad you brought that up, because I think that that's something the client almost needs to do before the prep session and bring it to the prep session.
And if they don't do it before the prep session, this is another good reason to start early, because it gives them some time to think about it and start thinking about those stories. I like to remind them too, not all of our clients are active and going out and playing soccer or kickball or anything.
Isn't it weird that so many clients work out? Like, I don't know what the percentage is of people in the United States that work out on a regular basis, but I have so many clients that are like, yeah, used to go to the gym 3 to 5 times a day or a week. And I'm like, you got 3 kids, a full-time job, and you commute an hour. How? And then I will ask my clients, like, do you have a gym membership? No. Do you have weights in your house? No. Okay. We're going to make sure that what you say is 100% accurate, because, there's no reason to somehow be, a fitness god before this crash, and now you're not.
Yeah. But I like to, even if it's cutting the grass or gardening or taking your dogs on walks, little things can be big things in our cases, if explained correctly, and how it really, I had one client who, one of her things was, she couldn't do her hair like she wanted, her arm, she couldn't. That's a big thing.
Yeah. I broke my hand playing lawyer softball, I think when I was first or second year lawyer, and I had a cast on, and it was like the cast that goes up to your thumb and covers your fingers. And I haven't seen anyone wearing this cast since I had one on, but I remember just going in Target one day and seeing like 4 kids, like they're like 6th graders, all with the same cast. And they're like, oh, holding up their cast, and I'm holding up mine. I look like an idiot. I'm a grown man. But I couldn't button shirts and I couldn't tie my shoes. And that's the example. And anyone out here listening to this, steal this, don't say it's you, but say, this is a good example, because I think it is. I tell clients, yeah, it hurt. Yeah, it stunk. Yeah, it didn't set right. It really, though, my biggest fear was, one, I couldn't wear shirts that had any buttons. And then if my shoe got untied, I'm like sitting there trying to somehow tie my shoe, looking like an idiot. And, that made me feel really embarrassed. I probably shouldn't have, but it did. But that's the thing that stuck for me when I broke my hand. It wasn't that I had to, wear a cast. It wasn't how bad it hurt when I fell. It was, I couldn't tie my shoes and I couldn't, button my shirts. That's when I felt helpless in life. And I think that was actually, that's something that clients, like cutting your grass, getting the mail, driving, all that kind of stuff. All right, Maggy Randels, anything you want to promote of yourself by chance? Anything you have going on maybe in the next 2 weeks in a format similar to this?
Yeah, I'll actually be doing my own webinar on May 18th at noon. And I will put the link to register in the chat.
That's some good, that's some good shit right there. That's really good.
Yeah. And so I'm going to be talking about liens and subrogation, and how I do it at the end of the case to hopefully help the clients get the most out of their settlement. And I hope that I can share something interesting and share some stories about how to stick it to the health insurance company when they claim it's an ERISA plan when it's not. So the link is there. It is May 18th at noon, also in a webinar format. And we, Shiver Hamilton Campbell does CLE for that. So you'll get 1 hour of free CLE, assuming I get my presentation to the bar on time, which I should.
Yeah, that CLE stuff takes a lot of work to do. So that's an awesome thing. I did it for the first couple of webinars we had here. And at the time we were doing them weekly, and it was just almost impossible to get CLEs. All right, I'm going to kick you out of here. Thank you so much for joining me. I really, really, really appreciate it. And hopefully, literally the window washer, by the way, is right directly in front of me.
So you watched your T-Rex hands on the
No, not a joke. Like the guy is like right here. I'm making this awkward for everyone, him and me. But I appreciate you joining me on here. And if anybody wants to reach out to Maggie, she's very easily to find. Her name is on her little picture right there, but I'll send an email out as well with her contact information so you guys have it. But there, and she just dropped it in the chat. So I'm gonna kick you out of here, Maggie, and then I'm gonna end this webinar just by talking to everybody just for 2 more minutes. And have a good day, Maggie.
Thanks for having me.
All right, bye.
Bye.
All right, everybody. The one question I didn't answer, and forgive me, I just saw it, is how do we instruct clients on answering questions on liability when they're asked, why do you think the defendant is at fault? Real quick, I think the answer to that is make sure your client has a common sense answer if possible. I think the defendant is at fault because I was rear-ended and I was just sitting there, and then put it on the lawyer. But hey, you'd have to ask my lawyer. That's why I hired him. I heard Steve is the best lawyer in the land, so you'll have to ask Steve all the details. I don't know everything there is to know about car crashes. So I want the client to give a common sense answer, and I want the client to then pass the buck. Adam Taylor just asked about non-client witness prep. I am at 1 hour and 5, I think, minutes or so, maybe a little bit more on this webinar. This may be one we're going to have to revisit as a part 2. We got a good group of people that were here today. I'm going to put a pin in that. And I think, sorry, Adam, I'm going to have to come back to non-witness prep because I think that is a a different animal. Although we wanted to talk about it, it was tough to get to everything today. So forgive me. Maybe that'll be something we'll talk about next time, and I'll try to put together a good topic for you. The next webinar, by the way, for June will be on Thursday, June 2nd. Thursday, June 2nd. I'll be sure to send out the link for that. But the last thing I want to leave y'all with is that there's been a lot of news this week coming out of the Supreme Court and about how that will affect how a potential ruling probably come June time. That's a thing, June time. A potential ruling that's been in place, I think, for the last 49 years could be overturned, and how that will change. I'm not going to touch that specific ruling, but I do want to touch the idea that, at least touch on the idea that the law is a dynamic and changing thing. And it's impossible to have all the right answers, and it's impossible to know everything, and it's certainly impossible to always do everything correct. What I hope the big picture takeaway, and I said it during the webinar, and Maggie agreed, and we talked about it, but what I hope on a big picture level, I hope your goal as a lawyer is to treat people fairly and get to the fair results in the most advantageous way. I'm going to use what Maggie said because I think it was really good. In the most advantageous way for your clients. But fairness, the notion of justice, has to come first. And the best way to be fair, whether it's as a lawyer or as a human, is to treat other people as you want to be treated. And don't judge people for the choices that they make or that they don't make, and the way that they handle situations, if they be different than you. So as you are guiding your clients through the process of being involved in a claim or a lawsuit, make sure you're real with them and tell them you don't have all the answers. Make sure you tell them that the law is always changing. You might be able to use a really good example, in a month here, of how settled law can change pretty much overnight. And how the decisions that we make about how we're going to prep our witnesses, the way that we're going to present our case, need to be true, need to be accurate and honest, and need to be as advantageous as they can to our clients. But be careful to never sacrifice your credibility, your honesty, and your reliability. I do these webinars, and everything I say gets recorded, and I voluntarily put it online. These webinars are sometimes used in my favor, and sometimes they're used against me by other lawyers, but I stand by everything I say on these things. And certainly things can be taken out of context, but that's a risk that I'm willing to take to try to help people and try to share what I think I know to help everybody who listens and watches these things. If you are willing to take some risks in your cases or in your life, make sure it's a risk, though, that you maintain your credibility and that you maintain your integrity, and that you are portraying yourself the way that you want to be portrayed and the way that you see yourself. So I think that if we take everything that's going on in the judicial world right now, I think if we all remember to treat other people the way we want to be treated, not judge people who make decisions that we either agree or don't agree with, and focus on ourselves and making sure that we do things that are true to ourselves and that are who we are. I think we're all going to do a whole lot better in the legal field and in life. So I don't know how related that is to witness prep, but I do think that there's a correlation, because as we sit in witness prep, and certainly as we sit in depositions, I think there's a temptation to cross lines, to overly, improperly coach witnesses. I think preparation is different than coaching. And certainly during a deposition, I think there should be no coaching. There should be no giving clients the answers. I think your job should be to make sure things are fair. And if you think things are not fair during a deposition, you should step up. Just like if you think things aren't fair in life or in court opinions that may be coming out or changing or have already come out, whatever your stance on things are, if you think things aren't unfair, or if you think things are unfair, do something about it. Speak out, say something. even if that means that it could put you in the crosshairs of somebody or jeopardize how much money you might make, how many cases you might get. I realize that sometimes I probably lose some opportunities because of things I've said on this webinar, and maybe today's no different. So if you feel that there's injustice going on in the world, maybe you should do something about it. And there's a whole host of ways to do things, whether that's, showing your support outwardly, donating to organizations you believe in, voting, whatever those things are. So anyway, I tried not to touch a hot topic issue. I failed. I told myself I wouldn't, but I had to do it. But I hope that everybody is doing okay in these changing times. I hope that that everybody has a safe and happy Cinco de Mayo, and have a tequila shot for me, and drown any woes you may have, or celebrate any good things that are going on in your life. If we haven't connected before and you're on this webinar watching me for the first time, I got a really nice email yesterday. Someone declared that I was their virtual mentor. Cool. That's awesome. Let's not keep it virtual though. I'm easy to find. Please reach out to me. I'll reach out to you after this webinar with our tips and with our my prep sheet that I've used before. So you'll have that, and you'll have my contact information, which I assume you have anyway if you're joining my webinar. But please don't be a stranger. Let's all get together. And thank you guys. I really, really appreciate it. And I just see Daquita Cooper is the person who declared, I think last night, that I was her that I was her virtual mentor, and I've got an email typed out to her that I need to send. So anyway, good talking to all of you. I'm excited for our next webinar. I'll be sending out details about that. In the meantime, be safe, be happy, and try to change the world for the better. See you.